answer to some questions. Is that okay?
Definitely, definitely, Mr. Chair.
Okay, thank you very much. So thank you very much. That has been a robust session, and I'd like to say we give a round of applause to the lead speaker and all the speakers. We shall be proceeding now to the question and answer session. But just as a way of recap, if I may, I recall the lead speaker speaking by and large about on multiplicity of action. He gave his definition, citing the case of Waigwe and FRN, brought into focus Section 24 and Section 7 of the EFCC Act, as well as Section 17 of the Advanced Fee Fraud Act. He reminded us of aspects of forfeiture which are civil as well as criminal. Whilst the criminal is as a consequence of criminal forfeiture is as a consequence of criminal conviction. One of the instruments in forfeiture realm is the interim order of forfeiture, which seeks to preserve the rest so that it is not dissipated, pending the action, during the pendency of the action. For civil forfeiture, he reminded us that it has to do with is an action in realm which preserves the property, or forfeiture is attached to the property without necessarily criminalizing the actual person. Thank God he played a major role in the Mafemi effort at recovering what was considered as the Abacha loot. He adverted our mind to the defense provided by the Abacha family that the circumstances of the day necessitated them midwifing and if you like, laundering or conveying these funds, national funds, in a way and manner that they wouldn't be shut down if the entire, continental, the world around chose to freeze assets. So there was a way of shielding the assets, Nigerian assets, from forfeiture. So this was the type of defense they tried to provide. Now, one thing I'd like to talk about is I was privileged to have been involved in one of these forfeiture kind of cases. It had to do with civil forfeiture and involved a judge, now deceased, where at the Federal High Court, where one of the security agencies embarked on a forfeiture proceeding against the judge. They said that judge had some amount of money in the account, and for them, it couldn't be justified. Well, we filed our counter affidavit challenging the interim forfeiture. But what I learned from there was that, one, we had a right of defense, which is the defense of fair hearing, to provide what was the source of funds and to show that these funds were not inordinate or they were not proceeds of crime and what have you. And then we said, look, you can't attach or forfeit this, the assets or the funds of the judge in the account. One thing I learned that was instructive for us there was that the judge in his judgment mentioned that after we shifted the scale by providing our defense, what the prosecutors did was, for them, they got their interim forfeiture. But they did not proceed beyond that to escalate their investigation beyond that. So they rested their case as it was during the interim forfeiture, as also it was for the final forfeiture. So there was no proper defense or no further prosecutorial evidence that came from them there. So speaking globally, it appears that from what we see now is even after the forfeiture, the prosecutor is still entitled to proceed with his investigations to show that indeed they have evidence or better evidence that can show that the funds in question are funds that were either laundered or proceeds of crime or one thing or the other. So, but luckily we won the case. So I mean, this is something we all would learn from on that side. And I'm glad and happy that the judge was set free. The property of the judge was also repatriated back to the judge. This was after about 2 years of trial, I think 2 years of trial. Yes. So yeah. So I know you talked about seized properties. Once properties are forfeited, oftentimes they are allowed to lie waste. We need to bear in mind that our circumstances in Nigeria here, bearing in mind how much time it takes to prosecute a matter, that look, something should be done creatively about, look, what happens to this property? Is there an insurance cover? Is there a bond that comes? These are issues that we should also think about. Again, the lead speaker spoke about the nature of trials in our country here. What we see here is that prosecutorial agencies or investigative agencies will arrest a defendant and then they go about seeking evidence or asking the defendant to incriminate himself and then asking for remand orders after remand orders. He juxtaposed this with what happens abroad, where he said that, look, abroad what happens is that the entire investigation is carried out. Once it is carried out and they are ready for prosecution, then they arrest. And in no time, prosecution commences. I recall that the Attorney General of the Federation recently made a pronouncement in that regard, that we should, and this is in public domain, that we should endeavor, that prosecutorial or investigative agencies should endeavor to conclude their investigations or go very far with their investigations before they prosecute, which is more or less the global standard. This is something which the lead speaker spoke about. I know, again, you talked about forum shopping, which could be seen about, you know, where agencies may look for the court which they feel is most amenable to them to take their cases to. I think these are some of the things I could relate with. Two cases that you mentioned that are instrumental or very instructive here are the Nwaboshi case and the Oje Uzo Kalo case. I urge that we all take time out to read those cases. Bordering on cybercrime, we can see also that defamation is one of the major byproducts of cybercrime. And then access of our data used and abused by security agencies of personal data. One question that comes to mind is what indeed is the jurisprudence of an agency like ECOWAS directing or determining what our laws here are. For instance, a law is passed in Nigeria and ECOWAS, if you like, UN, is saying that, look, that law does not fit into, what is the jurisprudence? I think you need to speak a bit to that. Now, we talked about sets and SOCs. Do they really exist? I don't know about them. I don't know who knows about them. If you have data challenges, even when there are emergencies, calling 122 or what number it is almost impossible in this country. So now you're talking about reportage of security and cybercrime or related offenses and data-related issues to organizations such as SET and SOC. Who knows about them? How do they function? Can you educate us, elucidate more on how we can have access to that? So that at one dial we're able to make our complaints and then we can actually see results, you know. And there was a case you mentioned that is of interest. Even though it was a high court case, I don't know if it's federal high court, the case of FRN and Igbokwe, right? Okay, please. I don't know if you can help us with further information. One question is, as important as that case seems, we want to know why was there no conviction in that case? Let's just know the facts, you know. And is it on appeal? You may not know, I don't know, but that's an area you probably would want to help us with. It's something because I recall you were indicating that was someone who was hacking into bank accounts or bank systems, and for what happened in that case. You know, those facts are very, very interesting. And Again, as a recap, Benedict DAUDU reminded us of the usual Nigerian prince that we hear about in the international space. With the internet and e-commerce, a common feature is what we ordered and what we get. There's a need for collaboration amongst security agencies so that there is no proliferation of 2, 3, 4, or 5 agencies working across purposes, and it becomes a major bureaucratic as well as security challenge for all of us. The aspect of AI doesn't appear to have been properly covered in the current existing laws. He spoke about that. What can be done about that? What are the possibilities of the amendments that we can have to bring our laws up to speed with what is international best practice? Of course, he talked about the need for training and continuous training and education, both practitioners, operators in the agencies, as well as even educating people in school environments as to these issues of cyber-related offenses. Ashoni Barrett talked about ethical and unethical hacking. He talked about access to, they say, awoof the rumbele, access to free Wi-Fi's and what have you. But the practical reality is that oftentimes when you travel around the world and you are at airports, you are unable to get your data uploaded, or you have a data in Nigeria on your phone, it doesn't work out there. You need to communicate with people as quickly as you can. There are a lot of Wi-Fi operators at the airports, international airports and in hotels. How do you know which one is safe or unsafe to click? Is this something that you can advise us on what to do? And again, our sister Chisom, did a recap of all of this, and so generally these are some of the informations that I am sure a lot of our colleagues will want to speak about, ask questions, and then we'll yield the floor to all our speakers, from the lead speaker to all the other speakers. And if you have any questions specifically for any particular speaker, you may say so. So we will now lead the floor for questions and answers. Questions, please. And we'll also bear in mind our colleagues online and our judges here, as well as members of the judiciary from KOGI and elsewhere. So the floor is open. First question, please. Yes, from the chairman of Kaduna branch. Barnawa branch. Your name again, please, and then just for the benefit of our other colleagues. Your name and
Bukola Jao, Barnawa branch chairman. While the second discussant was discussing, he touched, yes, Ashwani, he touched one area that has always bothered me. When it comes to, he said a man asked, you might say because I'm a woman, that's why I'm asking, but it's not because I'm a woman. I will go to the second question. Asked maybe a private detective to track his wife because he suspects her to be cheating. It's an example, but it's happening, we have it. So my question, that's for one, for a man that asks somebody to, yes. Then the second one is, for maybe you have an information that somebody is committing a crime at a disclosed place, maybe in a factory, he's moving out maybe things from the factory as a factory manager. Can you, without a report, plant a camera to begin to see, okay, throughout this week, how many cartons did he move out? That's the question. Can you do that just like that because you are the owner of the factory? Can you plant? You know, it's a different thing if it's a camera that is there that is covering everything. But because you specifically suspect him, you now planted the camera either to take his voice or his conversations. So I want to know if that will be right. Without first reporting, that is writing a report to the police, I suspect X, Y, and Z, and I need a private investigation. Can you just do that without going through that process? Thank you. Would that not be
invasion of privacy?
Yes.
That is very interesting. Ashonibori, we would like to hear you answer that. But I think we'll first take all the questions together and then probably just, but for the respective speakers, please take note of the questions that are directed in your,
Thank you. Good afternoon, Mr. Chairman, and thank you for the opportunity.
Is it okay if I say you sit down?
Sir, my questions are very few. I'll be sitting in a few minutes. My name is Chinelo Bozo. My question first is to Mr. Dayo. Please, beyond for data breach, beyond what is obtainable under these statutory provisions, these penal statutes, is there anything that someone can do under civil law for data breach? I ask this question specifically because of something that has been reoccurring every year. The culprit here is, as all of us know, MBA. Every year, candidates contesting for elections have our number by magic. People who don't know me, people who I've never met in my life. I'm glad that there are two chairpersons of MBA here. So they will not say that we are making a case against them behind their backs. And I'm sure when they were running for office, they too assessed those data. So is there any way we can do something? Data breach. Data breach, we are selling our data to contestants. And if they are making money from it, is there any way we can make MBA pay for, return that money that they've made from candidates to us? Then my second question is to Mr. the lead speaker, Mr. Enwelum, Senior Advocate of Nigeria. Sir, when you were discussing the Nwoboshi case, something that has been a well-known principle of money laundering, the issue of predicate offenses. Now, the prosecution agencies, I will blame it on the fact that they don't do their thorough investigation. Now knowing that predicate offenses have become the bottleneck of what they do because they don't do their proper diligence and investigation, they've gone to the new act, the Money Laundering Act of 2022, to seek to remove that requirement of proving the predicate offense. So if you look at sections 18, subsection 8 of the new act, they, if I may read, I apologize, Mr. Chairman, that I'm taking time. Section 18, after they listed what they mean by offenses, they now went to section 18 and said, notwithstanding the provisions of subsection 6, it shall not be necessary to establish a specific unlawful act or that a person was charged or convicted for an unlawful act for the purpose of proving a money laundering offense under this act. Now my question is this, can this provision stand in the face of what money laundering itself means? Can someone clean what is not proved first to be unclean? Then the next question, I think I'll come back to Mr. Dayo for my next question. Now, if you, I want to refer to some news that scattered the internet recently, where they said some investigation officers went to somebody's house to investigate a different offense, found materials, very heavy materials, and they released it on the internet and everybody lost their minds. The situation in Guinea.
I'm sure that is not in this country.
No, it's not. But it happens here sometimes. People release those kind of. Can that man, even though everybody knows he may not have the moral justification to go to court, but in case he's a very shameless person like myself, I will be shameless in that kind of situation. If he has the shamelessness to go to court. Yes, if he has the audacity to go to court and challenge, because it's a fact that it was them who took those tapes and released them to the public. Can he sue the government for breach of his own data and that of the privacies of the other people who were involved in those videos? Thank you.
Thank you very much. I hope that's the last question you asked, right? Okay, all right. Now let's go to questions from, let's do online questions first. And our friends from KOGI.
Hello, Mr.
Can we get anybody
Abdul?
from KOGI or anybody online? I know we have our judges and justices who are also partaking. Yeah.
Yes, Leonard.
Colleagues generally.
Yes. I think we'll have a question, one or two.
Is there any question? Has anyone been written? Technical, please, can you, if they send it? Oh, this KOGI there. Oh, okay. Okay, great.
Good afternoon. Can you hear me?
Yes, we can hear you. Thank you very much. You're welcome.
My name is Hassan Inesi Mohammed. I want to ask this question. Can you categorize the consistent failure of USSD codes, e.g. *737#? Once you die, you are debited 6 naira 98 kobo, and you are debited immediately. And there's this consistent failure and you are still debited, and the transaction is a failure, and you are still debited. Can you categorize that as transaction fraud? That's my question.
That's an interesting question. Yes.
Thank you. We have one more.
Okay, one more from.
Okay, we know that.
Sorry, I don't know if you can introduce yourself. The immediate past speaker didn't introduce himself, so if you do, we'll be happy.
Yeah, I think he did.
Oh,
But
he did.
please.
Okay, sorry, we're not sure. Okay, please, can you tell us your name again?
My name is Hassan Enesi Muhammad.
Muhammad, you're most welcome. Thank you very much. Now let's get to the current speaker.
Okay, my name is Dr. Chris Balogun. When we talk about cybercrime, we know in Nigeria that anything that is beyond scientific explanation, we tend to run away from it. The reality is that certain issues or concept has come to stay, like cyber voodooism, which is an emerging field of studies. We have cyber shamanism, or the online occult communism, mysticism. Why I refer to all this is because of the criminal activities that are being associated with them. In 2019, we heard about the tantric rituals and astrology that were used by people to scam. And related to the Nigerian factor, we know about the Yahoo Plus that engage in all this kind of occult or mystical power to defraud people. We tend to run away from it. Even the FBI liaison office in Lagos, they tend to shy away because it's beyond human explanation, but they've come to stay. In fact, it's in the public space that a musician released a song that if you no get money, lock them. Whereby when they have their victim, they hypnotize them and they defraud them. We never had the sense of it when you talk about cybercrime. But the reality is that people have been victims of these people. You come online, they hypnotize you, and before you know, they wipe your account. And well, it has come to stay. I would like the speaker that are expert to at least look into it, because it's an emerging field of study, and it's a reality that people are using African traditional religion and mythology to exploit people. Thank you very much, sir.
Thank you very much. Any further questions from there before we get back into the hall? And if there's any question from any virtual participant, IT, please let us know. Technical. All right. Any question in the hall here? Anybody? Yes, please identify yourself and then let's know your name and then ask the question.
the justifications for hacking, because hacking is in twofold. There is illegal hacking, and there are instances where hacking can be legal. So I just want clarifications on that so that we can be well abreast. Thank you, sir.
Okay. I think we should take a last question if possible, and then our speakers will speak to it so we can. Any further questions? Okay. All right, that's the last question. So the lead speaker will take the first shot. Is that not working? Okay, no questions.
Thank you very much, Mr. Chairman. You drew attention to the directive of ECOWAS courts, and you wanted to know how or whether ECOWAS had jurisdiction to make such. However, Mr. Chairman, if we look at the direction that the ECOWAS court gave, if it were in Nigeria here, that would have been the end of the matter. But, and I'm sure you're also aware, being a very erudite practitioner, that a lot of our colleagues rush to ECOWAS courts to essentially get directions that are contrary to what our courts here will decide. What ECOWAS court based its judgment, direction on, is that this section of the 1925 Act does not comply with Articles 9 of African Charter on Human and People's Rights and the International Covenant on Civil and Political Rights. It was not based on our laws here, and if you recall, the Court of Appeal judgment in Solomon Okedara said that, look, the provisions of the Acts of 2024 was in order and did not offend from the, Chapter 4 of the 1999 Constitution, because cybercrime is incapable of direct definition, and that the restriction on freedom of speech was necessary in a democratic society in the interest of defense, public safety, public order, public morality, or public health, pursuant to Section 45 of the 1999 Constitution. In other words, the Court of Appeal in Solomon Okedara and Attorney General of the Federation were looking strictly at the provisions of our own Constitution and vis-a-vis the law that was being criticized. ECOWAS, on the other hand, is relying on African Charter on Human and People's Rights, as well as International Convention on Civil and Political Rights. In my view, Nigeria adopted these conventions, both International Convention on Civil and Political Rights, as well as African Charter on Human and People's Rights. And essentially, the content, the provisions of the African Charter on Human and People's Rights are almost the same with the sections of the Constitution being referred to. But since our court have decided this, I think Nigeria should abide by the decisions of our courts. That's my answer to whether ECOWAS can. ECOWAS can make their directions, but I think it's mainly advisory. It is not compulsory that Nigeria must carry out. The second one is the case of Osondu Victor Ibokwe, which acquitted Osondu Ibokwe on the grounds that the crime he was charged, the section of which he was charged, does not cover the specific offense he was charged with, and it has to do with only ATMs and POS. Chairman, I hope I'm answering your question. Yeah. Good. That was before the amendment of Section 7 of the 2015 Act. As a 2015 Act, only the offenses involving ATMs and POS terminals were capable of being offenses. And so Victor Ibokwe Osondo was discharged on that basis. And his offense he was charged with was hacking into a bank's computer from outside and illegally transferring millions of naira. It was after that that section was amended to include all payment applications, online banking platforms, payment technologies, and so on. I hope I've covered you. The final one is the Nwoboshi case raised by Mrs. Chinelo. Every offense has its elements. Every offense has its elements. And if our courts have interpreted those ingredients in a particular case, and the amendment is made without taking into account those elements, I think the decision of the court will still stand. If you recall last year, similar thing came up when we were talking about lawyers being bound to make disclosures of confidential information. And we, in my lecture here, we interpreted section 19 of the 194 of the Evidence Act vis-a-vis the Money Laundering Act of 2022, which you just made reference to. And our conclusion was that the Court of Appeal in two different cases had ruled that before a lawyer will be made to make disclosure, be forced to make disclosures, they have to amend section 194 of the Evidence Act. It is only after the amendment that it can stand. So the amendment they did in section in the 2022 Act could not stand. If we apply the same to Nwoboshi, Nwoboshi is simply, if you are talking of somebody has laundered money, we are now taking a simplistic interpretation of it. Laundered money, those are the words. You launder what is dirty. You launder what is illegal. You launder what is criminal. So the word laundering presupposes that, look, the thing was not even legal in the first place. Going back to say somebody will be convicted of laundering money without proof of predicate offense makes that section 18, subsection 8 you are talking about, untenable, and it should be inconsistent with the judgment of that Supreme Court. In every material respect, section 18, subsection 8 cannot stand in the light of that Supreme Court case, because it is saying you can prove money laundering without any predicate offense. How does that come about? So that is my own interpretation, that section 18, subsection 8 should be set aside. Thank you. Any other? I hope I've covered.
Well, I think you've covered the field. A round of applause for him. Thank you very much. DC, thank you very much. We'll take on Benedict Daudu. You'll take on, answer a few questions that are directed to you. Okay. But by the way, while we're proceeding, I must take out time to acknowledge two of our very, very eminent colleagues who are here. One is Abdul Yahaya, SAN, who has been here, even though his own session is much later. He's been here all day since 9 o'clock. So I want to specially I appreciate you, sir. Thank you so very much, and thanks for your indulgence. And the other is Obi Anozie, MNI. MNI SAN incoming by God's grace. He has always been a member of the house. I mean, he's someone who has always identified with the Rule of Law Development Foundation. And he's been here all through the time, so I'd like to appreciate you. Now let's go to Benedict Daudu.
Thank you, Mr. Chairman. I first want to take a shot at Chinelo's question concerning the MBA, because it's a very interesting one, although I wouldn't want to put some people in trouble. But the fact is that there are three hurdles that need to be cleared. One, consent, purpose of limitation, which is the purpose at which the data is being used, and there's a limitation period to which it is done. Then there's also transparency. How transparent has the MBA been in letting members know that their phones will be used in that purpose? And so the normal regulatory process is that once data is being used, it must be used for the streamlined purpose. That is, take for instance, there's a health drive being done in a certain branch. The branch is at liberty to actually use the data of its members and tell them, oh, there's notification that this is being done for the branch. Now, for specific electoral purposes, that is the question. Now, I think it is meant to be tested at a certain level, but I won't say what will happen, but it does not seem like they're actually, following the guidelines of regulatory bodies. And because our regulations have not really been tested, it will take somebody as brave as Chinelo to actually take it to court and see what will happen. Then back to the Banawa branch chairman's question concerning surveillance. Now, if you notice when you enter a black cab in the UK, the first thing you see is you are being recorded. Am I correct? So this is the same situation you must actually do. You have to notify the employees that this is a procedure that is being done, and that there is also a limitation to which you can keep the recordings. You can't say, because you stole something, I'll keep it for 50 years and I'll keep on showing it. So there's a limitation to the time that you would use and keep this data. So I think that's just a short answer to both questions.
Benedict, that's a very, very fine intervention. But for me, let me wonder a bit. How material is it, your source of evidence in the prosecution of a crime? How you got that evidence? Would you like to talk to us about that, or do I ask Imwenu? Because you are talking about source of the evidence, consent to get the evidence, and whether that evidence is admissible in a trial, for instance. Well, let's not go too far there. But I mean, it's something that I think should agitate our minds, So, yes. So that was what I just, Oh, okay, all right. Okay. Okay, well, I missed out on that. But the question is germane. The question I ask is all right. So it's something we should all agitate our minds towards. So, yes, now we'll take Dio. Dio, is it okay if we take our friend Chisholm? Let's not burn her credit today, because I know, Dio, usually you get an extension of time. So, thank you, so can we get Chisholm to come online and then... Technical?
I'm online, Mr. Chair. Mr. Chair, I'm online.
Thank you very much, Chisholm. Let's hear. Now, questions were asked, and some also pertain to your discussion. So can we have your intervention?
Okay, thank you, Mr. Chair. I'm not sure anyone was particularly directed to me, but I would like to address the last question, which seeks to make a clarification on legal and illegal hacking. I believe that was the question. So for me, we all know that hacking is some sort of an unauthorized access to data. That one is clearly illegal, even though, but legal hacking cannot be, legal hacking, for want of a better word, cannot be called hacking, because Cyber Crimes Act, for instance, makes provision for court-authorized access or interception of data, right? That is a situation where the court orders that access to data be granted or be given for investigation purposes. That one is clearly legal and cannot be called hacking. It can be called court authorized interception or access to data. But hacking, which is clearly illegal, is the one that is categorized as a crime, and there is punishment for it under the Cyber Crimes Act. I don't think any other question is specifically directed to me, but in summary, I would like to say that in the implementation, Benedict had already made the point that implementation of the Cyber Crimes Act is still quite a challenge. But I would like to say that in implementation, the little efforts we are still making to implement the Cyber Crimes Act, in implementation of the Act, we should bear in mind that there is need to balance the rights of individuals against the protection of cyberspace and the cybersecurity of the nation as a whole. Over. That is my intervention. Over.
Thank you very much. But I still give you 2 more minutes to cover the field in any area that you want to, because there are some questions that have been asked here, and I think I'll need 1 or 2 or more speakers to talk to them. So please, before we get to Ashonibari, I don't know if you want to just take another 2 minutes to speak to any of the issues.
I think you'd like to. You're free to hand over to Mr. Ashonibari. I think I've covered the key questions that I'd like to address. The rest of the questions were particularly directed to Mr. Ashonibari.
So I'll call on Mr. Ashonibari to answer to the questions asked, specifically directed at him.
Okay. Thank you very much, Lenesik. Yes, in the respect of course of action, Chinelo, Mrs. Chinelo, I'm so sorry. In respect of the course of action, section 51 of the NDPA provides for that. You can, under section 51, you have a right to commence a course of action as a data subject if you believe that your data has been breached. Section 51 of the Nigerian Data Protection Act 2023. Then this Guinea case, have you watched it? You watched it? Huh? Oh, okay. Okay, so under the Data Protection Act, there is what we call sensitive personal information. I'm talking about Nigeria. There's something we call sensitive personal information. And sensitive personal information, part of the classification of sensitive personal information is sex life. So if you notice what happened in this particular film that I did not watch.
You didn't watch.
Right. If you notice what happened there is that it's just for his own personal aggrandizement, and that is his private sex life. For me, I've argued in some places that I don't see any criminal offense there because there is consent, right? And the whole process is his own private sex life. And under section 30, section 65 of the Nigerian Data Protection Act provides for, yes, section 65. So section 65 provides for you to be sex as sensitive personal data. However, now the question is, the filming of those people, did they consent? Now this brings about what we call privacy notice. Now, if you're a data controller, just like my learned Mr. Benedict just said, you need to comply with the rules, purpose, limitation, all the principles that have been provided. How do you comply with it? Like DAUDU, now once I come into DAUDU, I need to see a privacy notice stating how my data will be processed. And it must be within the principle of processing personal data as provided for under section 24 of the Data Protection Act. But you know, we have not started implementation. I'm very sure you must have seen it in our banks. Immediately you enter banks, you will see privacy notice. And what are they reiterating in the privacy notice? They will state how your data will be collected and how it will be used. And one of the principles is what Mr. Benedict has said, purpose limitation. You must state it clearly there because it's a requirement of it. Going further is, if you use camera inside your office, I know our law did not specifically mention it. If you're using camera in an official place where people come in, you need to place a privacy notice to state that there is a camera. You can't just capture somebody without their consent. So that I will choose whether to enter that facility or not. But if it is inside my house, my private apartment, I don't need to give you privacy notice that I have a camera. However, if the camera is facing the road where every public person is following, you must also put privacy notice. Note that there is a camera here. Most organizations do it. Most organizations don't comply with it. But the issue there is that it's because this law is still very new. By the time we start implementing this law, in fact, the sanction in this law alone can make you rich. And by the time it makes you rich, most organizations will now start complying with it. In conclusion, now there is an organization in Nigeria, in Abuja here, known as Federal Housing Authority. When you go to Federal Housing Authority and you are filling, even before the Data Protection Act came in, if you are filling their visitors form, all the information you fill, you will not see anything. But because they want to protect the person, the only thing you will see, they will give you a provision where you put DA to show that it's that your actual neighbor that came. But for every other information you fill, I don't know how they got that paper. For every other information you fill, they are the only ones that have access to it. And it is commendable because that is how you can protect the information of a data subject. Because if I'm giving you the information, you need to show me. Now, what events like this do is, when you are coming to an event like this, in the form that you fill, you need to also consent that every photograph that will be taken here, you have given consent to it. It's also important. Because you can't just take my photo randomly and post it on social media. Yes, but implementation have not started, right? So, but every event, now once I fill the attendance, at the bottom page of the attendance, I hereby consent that every photograph that will be taken in this event can be shared. Do you understand? It is my personal data. The fact that I have come for this event does not subject you to showing my face out there. These are some of the issues that eventually our law will capture. Then I think there is another issue in respect of free Wi-Fi. Stay away from it, sir, sincerely. Because if you look at even the terms and conditions in those free Wi-Fi, I've tried it in a few airports traveling abroad. They will tell you that we cannot guarantee the security of your information. They state it clearly there. Just stay away from it. You understand? But you know, you can have a particular mobile device that doesn't have, don't make any e-transaction on it. You can use those Wi-Fi to do your WhatsApp call and done. But not that immediately you do that, you now remember that you have not sent money to some people and you start doing it right there. No. You can only use it for the purpose of making phone calls. Free Wi-Fi abroad most times are very dangerous, and they give you that notification, caveat that we are not guaranteeing the safety of your personal information in the event of, the terms and conditions always flash anytime you want to connect to that Wi-Fi. I'm very sure you usually see those, this thing. And I think that should be, okay, so USSD, I think is a regulatory issue, just like the learned Steve just said here. I think it has to do with providing quality of service by ISPs. There are duties that ISPs must comply with. And if you're not complying with that, it's a consumer issue. It's a consumer, is a consumer issue that you can bring an action against them. And there are relevant laws. For those of us that know FCCPC, FCCPC is doing very well. It's not that nobody is doing anything about it. Do you understand? If you report to FCCPC or even their consumer protection department within that organization, I can assure you that they will take over the case. So, but I think it's a regulatory issue. So, apart from that, I think, yes, ethical hacking and unethical hacking. Yes, I agree with Madam, the Speaker Chinelo, that said, yes, we don't have anything like ethical, sorry, we don't have it in our, there's nothing like hacking that is ethical. So once it is ethical, it is not hacking. Now the difference is when you have authorization to access a particular device, it's ethical. I know back then, Bayelsa State government recruited some hackers for about 80-something million naira. I read it over the papers. You can bring people to work for you in your organization to carry out this, but you must ensure that you have authorization. The missing line is that once there is no authorization and you continue with accessing those information, then that is unethical. Because we also have activists. If you have heard of activists, what they do is that they hack to expose corruption. We know WikiLeaks, right? We know most of them. What they do is that they just look for how to hack. After hacking, they expose corruption, the Panama Papers. Most of those things, they do it. But that doesn't make what they do what? Ethical. I think apart from that, that's it. Thank you very much.
Thank you. I think I talked about, there was this talk about SET. This is what is SOC and CART, yes. Yes, can you, SOC, right? Yes, can you talk about it? Because I was telling you that how do you lay your complaint and, you know, It hasn't been implemented. Okay, hold on. Just speak to it.
It's a provision of the Cyber Crimes Act, but it hasn't been implemented yet. And implementation will include setting up those sets where people can make direct complaint to.
All right, thank you. It's also a wake-up call to our emergency dial numbers, because I don't know how very functional it is. Like I said, all over the world, you can, once you are in difficulty, you can call for emergency, but you know, it's still a problem here. So, anyway, thank you very much. We have learned a whole lot here. We are richer in knowledge. We are better informed. And in fact, this already is satisfaction. So I do not think anybody is as good as saying there's no need for any tea break or lunch break. This is already filling. But I'd like to thank my Lord and my Lords who have been here all day. I'd like to thank the lead speaker as well as all the other speakers. I'd like to thank my brother Silk, Abdul Yahya SAN, and Obianozi MNI. The distinguished gentlemen and ladies here, our colleagues who are particularly from KOGI and elsewhere around the world who have joined us virtually. I do believe that as we do yearly, the communique and papers will be available to enrich the legal community and beyond. May I especially mention Hajia Musa Yusuf Falilat, who is the Solicitor General and Permanent Secretary, Ministry of Justice in Kogi State. I'd like to thank you very, very specially for your time with us. And if I may also go to mention the names of my lords, I'd like to personally acknowledge them. My Lord Adamu J, my Lord Suleiman J, and my Lord Yakasai J, all from the Kano State Judiciary. My Lord Umar J, my Lord Salisu Umar J, my Lord Watana J, and my Lord sorry, may I be corrected? Fatima Garba Yakasai is not my Lord. I'm sorry about that. Sorry about the earlier pronouncement. So the name is Fatima Garba Yakasai. And I think representing the DCR of Kano State High Court, who also doubles as special assistant to the CJ. Please, warm regards to the CJ and the judiciary of Kano State. We appreciate Fatima Garba Yakasai. Well, thank you so very much. I appreciate every one of us. Thanks for your time. Thanks for your patience, your attentiveness. And like I said, we're all better. We're better educated. We're enriched. And I'd like to mention that when you are talking about MBA data, please leave those cases until after. Let some people make good use of those cases first, those data first. those who know. So I say no more. No, those who know, please wait. And you chose to make this to raise this issue when I'm here, and this is not fair. But but it's all right. It is noted. So please just thank you very much. So I appreciate it. So I think we'll talk about the breakfast or lunch break now, the tea break now. So up to you. Thank you very much. It's such an honor, gentlemen.
Another big round of applause for our chairman, please. Thank you very much for anchoring the session today. Thank you. That brings us to the end of the session now. We would rise for the national anthem.
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peaceful battle honored, and this we contest gain. To hang unto our children a banner without stain. O God of all creation, grant this our one request. Help us to build our nation where no man is oppressed. And so with peace and plenty, Nigeria may be blessed.
Thank you very much. Would like to invite our distinguished guests and panelists for a tea break upstairs. Yes, would have photographs immediately. Cameraman, could you please? Would all the panelists please come forward for a group photograph? Can we please have the photograph? Our distinguished guests, my lords, for a group photograph.
Please, let's quickly take a group photograph.
Tinkonko, tinkonko, ogongo lobe. Tinkonko, tinkonko, inni ulobe ogo. Women they like her cocoa. Every time they chop her dodo. Now I so bokolo, maybe I so polo. You don't go here, say she don't go alone. That your boy I do go. They make them dance and song go. Don't call her. Say you won't talk her matter. You not act like but still she don't want your matter. But still she don't want your matter. Tinkonko, tinkonko, ogongo lobe. Tinkonko, tinkonko, inni ulobe ogo. Tinkonko, tinkonko, ogongo lobe. Tinkonko, tinkonko, inni ulobe ogo. Yeah, baby, kill off baby, baby, go borrow. Mama Bobo, love Bobo, Bobo, Bobo. One do we better, Mama Jabba, Crescent in the night. Crescent in the Mama River, Crescent in the night. Crescent in the night. Crescent in the night. You better understand. You know, Tinkonko, tinkonko, ogongo lobe. Tinkonko, tinkonko, Every time they drop her DAUDU, now so cool. Need so cool. You don't hear say she don't go let your boy I do go. They make them dance as zonto. So you can call her say you want to her matter. You not act that still she don't want your matter. Still she don't want your matter. Tinkonko, oh gongo love. Tinkonko, inni ulove rago. Tinkonko, oh gongo love. Tinkonko, inni ulove rago. Yes, this is the illest now, brother. XB sound. Oh gongo love. Inni ulove rago. Yes, sir. COVID-19 now, virus yo. It's a killer virus, a wicked virus, a serious virus, a wicked virus. But we are go, we go mash am go down, we go cast am go out, we go kick am go out, we go mash am go down. Yes, Leverage, which one down come in? China English, I mean Bangladesh. Na pandemic, this not a comedy. And the remedy, wash your hands steadily. A great tragedy, many in a cemetery. It's a frenzy, turn the world itinerary. For the lockdown, many they talk gibberish. For Africa, people they hungry. And the government go try yo. COVID-19, now virus yo. It's a killer virus. It's a killer virus, a wicked virus, a serious virus, a wicked virus. Any, Tantagba, Eri Morocco, Bimo Banke, Nino Ile, and you can't hear that you go Jule, and what Bam shame we could tolerate as we isolate and keep it in the Mare. Yes, Jehovah, Ele du your sister, everybody, please, let's play safe. We only got today, we only got ourselves. COVID-19 now, virus yo. It's a killer virus, a wicked virus, a serious virus, a wicked virus. We go mash am go down, we go cast am go out. We go mash am go down, we go cast am go out. We go mash am go down, we go cast am go down. Yes, this is the illest now, brother. Pandemic rhythm, 2020 XP sound. From Nigeria to the whole world, you know. Coronavirus can't kill us. We're gon' kill it. We're gon' bit it. We're gon' kill it. We're gon' bit it. We're gon' kill it. Yes, Nigeria, Ghana, Paris, France, America, Europe, UK, Jamaica, Asia, Toto, South Africa. About the root law. XB sound. Let's make road. When it's a step, got you locked down. Make it wanna scream, make it wanna shout. Make you vex less, make you worry less, make you stress less. You go wanna sing. No, Lily. No, Lily. No, Lily. No, Lily. No, Lily. No, Lily. Listen, my brother, where you go? Are you cock up, nice up? I ask you where you dey go. I dey see you fight your brother. I dey see you meet your brother. I dey see you rob your brother. So I say to you, fix your brother. What goes up must come down. What goes wrong must think time come around. When you do crime, you must hold time. Who is to blame for your dirty games when the time come around? You're in handcuff time and in a rough. No, lily. No, no, lily. No, lily. Hey. No, lily. No, 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 lily. No, lily. No, lily. I feel so sick with a future big when it's gritty. Take the city, take the weak and the needy. No the logic, then the mathematics. When there was strategy, be the only remedy. It's delusional, and it's a no brainer. Politicians, them are scamming us with them sweet words and them evil like thugs. It's so critical, and it's illogical. When you dream big, make it dream big. Also get them above the sky, be your limit. When the system got you locked down, make you wanna scream, make you wanna shout. Make you vex less, make you worry less, make you stress less, you go wanna sing. No, lily. No, no, lily. No, lily. Hey. No, lily. No, 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 lily. No, lily. No, lily. My brother, where you go? I pick up, nice up. I ask you where you dey go. I dey see you fight your brother. I dey see you meet your brother. I dey see you rob your brother. So I say to you, fix your brother. What goes up must come down. What goes wrong must think time come around. When you do crime, you must hold time. Who is to blame for your dirty games when the time come around? You're in handcuff time and in a rough. No, lily. No, no, lily. No, lily. Hey. No, lily. No, 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 lily. No, lily. No, lily.
This is not of Africa of freedom. Ex-Minister all around the world.
With the leave of the chairman, Mr. Abdullahi Yaya, Senior Advocate of Nigeria, we now call this session to order with the national anthem.
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peaceful battle honored, and this we contest gain. To hide unto our children a banner without stain. O God of all creation, grant this our hungry thirst. Help us to build our nation where no man is oppressed. And so with peace and plenty, Nigeria may be blessed.
Thank you very much. We may be seated. As you all know, the topic for this session is Operation Save the Naira, and the chairperson is no other person, as I stated earlier, the capable Mr. Abdullahi Yaya, Senior Advocate of Nigeria. I'll just go through his professional background very briefly. You may please give him a round of applause. Mr. Yaya, Senior Advocate of Nigeria, is a distinguished and dedicated Senior Advocate of Nigeria, specializing in civil and criminal litigation and appeals, commercial and corporate litigation, and election petitions. He has a career spanning several years. He's a registered capital market consultant. He was conferred with the rank of Senior Advocate of Nigeria in the year 2020. He has been very active at the branch level in various roles within the Nigerian Bar Association, Kaduna and Barnawa branch, and more recently at the national level. At the branch level, he has served both as member and chairman of various committees in Kaduna and Barnawa branches, and then lately, chairman of the Barnawa branch of the Nigerian Bar Association. At the national level, he has served as a member of the National Executive Council 2020 and is currently a member of the Electoral Committee of the Nigerian Bar Association. He was a member of the Judicial Commission of Inquiry into the management of some ministries, parastatals, and extra-ministerial departments of Bauchi State, established by the Governor of Bauchi State between the period of December 2007 to 2009. He has also served as chairman, Kaduna State Local Government Election Tribunal between 2012 and 2013. He is a member of the National Productivity Order of Merit Award Committee. Mr. Abdullahi Yaya, Senior Advocate of Nigeria, is a devout Muslim, married and blessed with children. Please, a round of applause. Thank you very much. We welcome you, sir. We also have with us Mr. Eti Kende, Senior Advocate of Nigeria, who is the lead presenter, and is ably represented by Mr. Leke Kende. Please, may we give Mr. Leke Kende a very big round of applause. Mr. Eti Kende is a distinguished Senior Advocate of Nigeria. Proud of founding his firm, he worked as an associate at Paul Lusora & Co., a leading Nigerian law firm, where he gained his areas of expertise include corporate, commercial law, dispute resolution, and he provides top criminal advisory services to clients across various industries. He's also an expert in criminal law and a member of Nigerian Bar Association, International Bar Association, and various other professional and industry-specific legal associations. Please, let's give him a round of applause. We also have with us Chinelo Audrey of Foigbunam. She's a dynamic and ingenious, noble and vibrant associate, advocate, an innovative business advanced expert who has undertaken relevant training in law, advocacy, business administration, governance, arbitration, leadership, and a host of others. She's an associate with Law Office of Kayode & Co. Since 2017, where she focuses on effective implementation of evidence, result-oriented paths, cases, fulfill clients, and exceeds expectations. She's a dedicated and compassionate person, and indeed an advocate for justice and peace. She's received several awards, medals of excellence, and honorary awards for humanitarian acts. Audrey is a Youth African Leadership Initiative Fellow, a Paul Harris Fellow, a benefactor of the ADR Neutral, Federal High Court Alternative Dispute Resolution Center, and author of Weekly Legal Tips series. She speaks English, Igbo, and French, and loves playing badminton, listening to music, researching, writing, traveling, and swimming. Please, let's give her a round of applause. Thank you for coming today. Thank you very much. We would recognize other distinguished personalities in earnest. I will yield the microphone to our chairman. I'll yield the microphone to the chairman and introduce Madam Chinere Moneme before she takes her paper. Thank you very much.
Once again, I welcome all of us to the afternoon session of this 5-day Rule of Law Development Foundation Annual Criminal Law Review Conference. The topic, as we've been told, is Operation Save the Naira, understanding the purpose and scope of Section 21 of the CBN Act 2007, the prosecutorial limits of the state, if any, the liabilities of persons, and the prohibition of currency mutilation and abuse and allied offenses, the Bobrisky and Cubana chief priest dimension. Before delving into the paper, I wish to recognize in attendance the coordinator of the Rule of Law Development Foundation, who is with us online, my Lord, the Honorable Justice Oredola, JCA, retired, who has for Monday been here always before 9. My Lord, we do sincerely thank you. I also want to recognize the presence here with us, the Honorable Justice Hadiza Suleiman of the Kano State High Court, Honorable Justice Fatima Adamu of the Kano State High Court. Also in attendance at the Glass House in LOKOJA, joining us virtually, our Honorable Justice M.E. Umar, Honorable Justice Salisu Umar, Honorable Justice Moses Guatama, Honorable Justice A.O. Salisu, and the several magistrates and directors from the KOGI State Ministry of Justice. Also in attendance is Hajia Musa Yusuf Alilat, the Solicitor General and Permanent Secretary, KOGI State Ministry of Justice. We also have here Fatima Garbaya Kase, sitting in for the Deputy Chief Registrar Litigation, Kano State Judiciary. Also here with us is the representative, as has been introduced, of the lead speaker, Mr. Oluwagbemileke Kende, and the other discussants to this paper. Joining us online among the discussants is Dr. Agada Elechi, Senior Advocate of Nigeria, who will be joining us virtually. I also want to recognize in our midst Mr. P.B. DAUDU, Senior Advocate of Nigeria and Branch Chairman of Buhari Branch of the Nigerian Bar Association. I also want to specially recognize all of the conferees who have been here, either physically or virtually, attending this conference. Gentlemen, I welcome you all and I congratulate you for finding time to attend this conference. Now, without much ado, time having been fast spent and walking from behind schedule, I will yield the microphone to the representative of the lead presenter, Otumba A.T. Kende, to take us through the lead paper so that we can straight go into the business of the day without wasting much more time.
Thank you, Mr. Chairman. Good afternoon, distinguished colleagues, guests, and esteemed audience. My name is Oluwagbemileke Kende, and it is my great honor to present this paper on behalf of Akinlolu Kende, Senior Advocate of Nigeria, who unfortunately cannot be here with us today. I would like to thank the Rule of Law Development Foundation and the organizers of this conference for giving me the opportunity to present this paper on behalf of the learned Senior Advocate. The paper, titled Operation Save the Naira, examining the prohibition of currency mutilation and abuse under Section 21 of the Central Bank of Nigeria Act 2007, addresses the legal framework against the abuse of the Naira. The issue cuts to the heart of national identity, economic stability, and societal values. Our discussion today focuses on the prohibition of currency mutilation and abuse under Section 21 of the Central Bank of Nigeria Act 2007. Now, why does the Naira matter? Currency is the lifeblood of any economy. Beyond its functional role as a medium of exchange, it is a potent symbol of national pride and sovereignty. For us, the Naira is not just a means of transaction, it embodies our economic and cultural identity. Section 21 of the CBN Act explicitly prohibits the abuse and mutilation of the Naira and imposes penalties for violations. Yet, enforcement has been limited and public awareness of this law remains minimal. However, recent prosecutions involving high-profile individuals, such as Idris Olanrewaju, popularly known as Bobrisky, and Pascal Okechukwu, also known as Cubana Chief Priest, have brought this issue into the national spotlight. Today, I will examine the legal framework for Naira mutilation and abuse, explore parallels in other jurisdictions, and propose a multifaceted approach to eradicating the abuse of the Naira. What constitutes Naira abuse? The term abused is defined as a departure from legal or reasonable use. Abuse of the Naira is a broad term that encompasses actions such as defacing, tearing, stapling, soiling, writing, stepping, hawking, selling, or spraying Naira notes during social events. These acts have all been criminalized by Section 21 of the CBN Act. Therefore, they constitute an abuse of the Naira. Nigeria is not alone in prohibiting the abuse of its currency. In the United States, mutilation or defacement of the dollar is a federal offense that is punishable by a fine or imprisonment. Australia, Singapore, and the United Kingdom enforce similar laws, underscoring the global recognition of currency as a national symbol deserving respect. While sanctions may vary across jurisdictions, the principle remains the same. Currency abuse undermines economic integrity. Jurisdiction and enforcement of Section 21 of the CBN Act in Nigeria. Under Section 251, subsection 1D and 2513 of the 1999 Constitution as amended, the Federal High Court clearly has exclusive jurisdiction over criminal matters relating to the abuse of the Naira. Enforcement, however, is not so clear-cut. The Economic and Financial Crimes Commission has the general investigative and prosecutorial powers over economic and financial crimes. From the definition of an economic crime under Section 46 of the EFCC Act, the intention of earning wealth illegally must be present before an act may be considered as an economic crime. Abusing the Naira does not necessarily require an intention to earn wealth illegally. Consequently, an argument can be made that the EFCC does not have the power to investigate or prosecute persons who abuse the Naira without any intention to earn wealth illegally. Furthermore, the Central Bank Act is not among the list of statutes that the EFCC has the power to enforce under Section 7, subsection 2 of the EFCC Act. Nonetheless, a function of the EFCC under Section 6 of the EFCC Act is to take charge of, supervise, control, and coordinate all the responsibilities, functions, and activities relating to the current investigation and prosecution of all offenses connected with or relating to economic and financial crimes. The pertinent question here is abusing the Naira sufficiently connected with or related to an economic crime as defined under Section 46 of the EFCC Act? Unfortunately, I am unaware of any judicial pronouncement on the preceding poser, and until a binding judicial pronouncement is made, a commentary on the issue is academic and beyond the scope of this paper. Despite the foregoing, on 7th of February 2024, the EFCC announced that it has raised a special task force against the dollarization of the economy and mutilation of the Naira, and has successfully prosecuted persons before the Federal High Court for abusing or mutilating the Naira. The Nigerian police force, however, is vested with the powers to investigate, arrest, and prosecute criminal offenders in Nigeria. The Nigerian police force can therefore investigate and prosecute violators of Section 21 of the CBN Act. However, The prosecutorial powers of the Nigerian police force is subject to the power of the Attorney General of the Federation to institute and take over criminal proceedings. Challenges and legal issues. The effective enforcement of Section 21 of the CBN Act is faced with the following challenges. 1. Cultural norms. Spraying of Naira notes are deeply ingrained in celebratory traditions in Nigeria. Many are unaware that such actions constitute a criminal offense. 2. Cost of prosecution. Prosecution is resource intensive, and prioritizing this offense may strain government resources better directed elsewhere. And 3. Public awareness. Many Nigerians remain unaware of the provisions of Section 21 of the CBN Act or the rationale behind it. A multifaceted approach to change. To eradicate Naira mutilation and abuse, a punitive approach alone will not suffice. A comprehensive strategy is needed. This strategy encompasses the following. 1. Public awareness campaigns. The Central Bank of Nigeria and relevant agencies must lead sensitization efforts to educate citizens on the legal, economic, and cultural implications of currency abuse. 2. Cultural reorientation. Collaboration with community leaders, event planners, and the private sector can help shift norms surrounding celebratory practices involving the Naira. 3. Alternative penalties. For first-time offenders, fines and community service may prove more effective than imprisonment, reserving harsher penalties for repeat violations. 4. Capacity building for enforcement. Training law enforcement and judicial officers to effectively handle cases relating to the abuse of the Naira is crucial. In conclusion, ladies and gentlemen, the Naira is more than currency. It is a representation of our collective identity and aspirations. Currency mutilation and abuse are not victimless crimes. They impose economic costs, slow banking operations, and erode national dignity. The goal should not be to punish isolated offenders, but to reshape societal attitudes towards the Naira. Through education, collaboration, and pragmatic enforcement, we can ensure that the Naira is treated with the respect it deserves. Let us commit ourselves to this noble cause. To save the Naira is to safeguard the very essence of our economic and cultural heritage. Thank you.
I believe I speak for you when I say Mr. Kendi has ably delivered on the, and in very apt time. I realized it was even better that I did not set a time limit for him, because he has done so in about 15 to 20 minutes. I think he deserves another round of applause from all of us here present. Now, just before we take our discussants, I will yield the microphone to our MC to take the introduction of Mr. Dr. Agada and that of Chinyere Monime.
Thank you very much, sir. Very quickly, just to introduce our next speaker, Dr. Agada Elachi, Senior Advocate of Nigeria, Fellow of the Institute of Chartered Mediators and Conciliators. He's also a Fellow of the Chartered Institute of Arbitrators and a past President of the Institute of Chartered Mediators and Conciliators. He's the founding partner and presently managing partner of the firm. He holds a degree in law from University of Jos, Plateau State. He also holds a doctorate degree, PhD in public policy and administration, specializing in terrorism, mediation, and peace from the prestigious Walden University, USA. He holds a postgraduate degree in Peace and Conflict Studies from the University of Ibadan and is a member of the Society for Peace Studies and Practice. He also holds a master's degree in law from Nasarawa State University, Kefi. He has been engaged in active legal practice with a bias for the resolution of disputes outside the conventional litigation system. He has various experience in the practice of law, covering areas like commercial law and company practice. We thank you very much for coming. Please let's give him a round of applause. Before we yield the mic, we would just like to recognize the presence of Chinyere Moneme Esquire, who is a partner, Crystal Legal and Arbitration Consultant. Let's give her a round of applause. She is a respected and dedicated legal practitioner and consultant with expertise in various areas of legal practice, including arbitration, litigation, and other legal consulting within the legal community. As both partner and consultant, she plays a key role in the firm's strategic direction while offering specialized legal guidance to clients on complex matters. She's chaired the Sexual and Gender-Based Violence Committee between 2021 and 2023, contributing to significant legal reforms and advocacy. She's also a member of the Chartered Institute of Arbitrators, SA. Thank you very much for coming.
Taking the introduction of Mr. Agada-Elechi and Chinyere, I think we will quickly go to Mr. Agada. Technical, do we have Dr. Alechi? All right. Doctor.
Yes. Good afternoon, my chair. Can you all hear me?
Yes, we can. We can. You have 10 minutes, subject to
10 minutes
of time.
Well, very well. Thank you, sir.
Yeah.
But first of all, let me apologize for joining electronically, that's online. I wish I was there, but I'm currently in the Northern. I came for a matter, and I've just had to rush to find myself seated here now, ready to make this presentation. I'll try my best to stay within the 10 minutes time limit. I have a paper which I presume has been shared, but if not, I'm sure will be shared to all the participants subsequently. I just begin by thanking David DAUDU and the Rule of Law Foundation for this opportunity. My task is to speak to as following the lead speaker, to speak on understanding the purpose and scope of Section 21 of the CBN Act, the procedural limits of the state, if any, the liabilities of persons, and the prohibition of currency mutilation and abuse and allied offenses, and the particular cases of reference are the Bobrisky and the Cubana Chief Priest case. I begin my paper by saying that in Nigeria, the integrity of the Naira has been increasingly threatened by practices that undermine its value, such as currency mutilation and abuse. And to combat these abuses, these issues, the CBN has attempted to implement Section 21, the CBN Act. Of course, the phrase Operation Save the Naira aims to restore the public confidence in the value of the Naira, and hence the enforcement of this Section 21 of the CBN Act in support of the Save the Naira policy is as showcased in the cases of Bobrisky and Cubana Chief Priest, who faced charges of Naira abuse. Now, with regards to Operation Save the Naira, Operation Save the Naira is a long-standing initiative aimed at preserving the value and integrity of Nigeria's currency in response to the persistent devaluation and economic challenges. Originally conceptualized by the late economist and columnist Sir Henry Boyo, this initiative combines public awareness efforts, policy critics, and legal enforcement to address both the immediate and systemic factors affecting the Naira. I just keep the next few paragraphs, go straight to the background on currency mutilation and abuse in Naira. Currency mutilation and abuse, especially in the spraying of Naira notes at social events, is a widespread phenomenon in Nigeria. Many Nigerians perceive this practice as a cultural norm rather than a violation, which complicates the enforcement efforts of our security agents. This cultural acceptance and selective prosecution by authorities creates a perception of favoritism, making it challenging to address the practice uniformly and holistically. If I may just digress, one of the major challenges in this area is when you talk to people about the issue of spraying of Naira, you hear people say that it's part of our culture. And one of the questions I have put to audience when I speak about this is, when you say it's our culture, culture is said to be the practice of a people developed over time. And I know for a fact that as a people, we used to trade in cowries and shells in the past. So I do not know whether at that time we were also spraying cowries and shells. And this is a poster for the audience. Maybe somebody will be able to provide information on that. Enforcement with regards to currency mutilation has predominantly targeted on currency counterfeiting, as illustrated by the imprisonment of over 3,200 individuals between 2018 and 2020 for counterfeiting-related offenses under the Counterfeit Currency Special Provisions Act. This indicates that while legal frameworks exist to combat currency-related crimes, societal practices like spraying or defacing of the Naira have yet to receive the focused legal attention. The tradition of spraying money spraying has deep roots. It is interesting to note that this is not exclusive to Nigeria, because in countries like Cuba, Hungary, and Ukraine, some of these practices have been there. Originally popularized through Yoruba Juju music performances, where attendees will shower musicians with money as appreciation, it has since spread to weddings and other celebrations, including burials. Today, spraying money remains a prominent feature of Nigerian weddings and public gatherings, often serving as an opportunity to display wealth and social status. In 2019, the Central Bank of Nigeria introduced a clean note policy to maintain banknote quality and curb currency abuse. However, the initiative lacks sustained implementation, allowing money spraying and related practices such as hawking new notes to continue unregulated. Additionally, despite anti-Naira abuse laws, enforcement has been limited, and high-profile cases of extravagant currency displays continue to draw public scrutiny. So what is the purpose and scope of Section 21 of the Central Bank Act 2007? The objective of the Central Bank Act was incorporated to establish a strong legal foundation for protecting the integrity of Nigeria's currency, the Naira, from acts that could compromise its physical state and public perception. This Section 21 of the Act provides, as stated therein, I'll take it as read because of time. Thank you, Chairman, for your permission in that regard. The primary objective of this provision is to safeguard the Naira from abuse and mutilation, preserving its status as a respected and trustworthy medium of exchange. This legal protection is crucial for maintaining both the economic and symbolic value of the currency, as the physical quality and presentation of money contribute significantly the public trust in the financial system. Many of you will be familiar with the fact that sometimes when you give people money, they tell you, I won't accept this, I won't accept that, and so on and so forth, either because the money is mutilated or torn. All of these are a product of the abuse that many of us are undertaking. The second point to note is the overview of Section 21 specific prohibitions and their clear aims. Section 21 of the CBN Act enumerates specific prohibitions to prevent acts of tampering, abuse, and trading of Nigeria's currency. This section criminalizes various forms of currency mutilation, defining clear and specific offenses that carry legal penalties, including imprisonment and fines. Key prohibitions are: 1, tampering with coins and notes, and the penalty here could be 6 months imprisonment or a fine of at least 50,000 or both. The second is definition of tampering. Section 21 defines what tampering is, and Subsection 2 particularly offers a broad definition of what constitutes tampering to go beyond mere physical impairment and to include actions such as defacing, engraving, mutilating, piercing, stapling, or writing of notes. So those of you who occasionally, in trying to remember something, quickly scribble it on the Naira note, you will be guilty of tampering, and you could to jail for 6 months or at least a fine of 50,000 or both. Social practices as currency abuse. Subsection 3 addresses cultural ingrained practices such as spraying, adorning individuals with currency at celebrations, dancing on currency, stepping on scattered notes. There's a common practice now called, I hear people call it a bouquet of flower, some call it money cake. I do not know whether the strict interpretation here would apply to that, but I suspect that people may run into trouble in that regard. Prohibition of trading in Naira. Subsection 4 further prohibits the hawking, sale, or trading in Naira notes. However, we all know that this is very common and rife, especially at occasions. And interestingly, for those who go to lounges and so on and so forth, I hear that sometimes you have people who will carry as much as ₦1 million and trade it for certain considerations in such places. Then clarification of key terms. Section 21 also clarifies key terms touching about on things like matching and spraying. And in terms of matching, it includes spraying, spreading Naira notes or coins on surfaces for any occasion, while spraying includes decorating or sticking Naira notes. This is what I talked about, the issue of money cake or bouquet of flower. These are some of the things that people do without knowing that they may necessarily be violating the law. Now, violations of Section 21 of the CBN Act as an act of economic and financial crime. Section 46 of the EFCC Act defines economic and financial crime as illicit activities conducted with the goal of unlawfully acquiring wealth. These crimes include actions that violate government regulations on economic activities and cover offenses such as fraud, money laundering, bribery, counterfeiting, tax evasions, foreign exchange malpractices. While currency abuse and mutilation as outlined in Section 21 of the CBN Act, such as defacing, spraying, or trading in Naira, may not be explicitly included in the broad definition of the economic crimes under Section 46 of the EFCC Act. The prohibitions in Section 21 against actions like defacing, spraying, or trading the Naira qualify it as an economic crime. This interpretation allows the EFCC to consider currency abuse under Section 21 of the CBN Act as a prosecutable offense within its jurisdiction. So I've heard some people say, oh, EFCC doesn't have jurisdiction. Well, I'm of the view that they do, and we must be careful as we carry out our activities. Now, enforcement of Section 21. Enforcement of Section 21 of the Act falls primarily to the economic and financial crimes, along with other relevant authorities. These agencies are responsible for investigating and prosecuting offenses while ensuring compliance with currency protection. And I have quoted there in Section 7, Sub 1 and 2 of the EFCC Act 2004. Summarily, the EFCC's authority to address currency abuses comes from Section 7 of the EFCC Act 2004, allowing it to investigate economic crimes, examine questionable assets, and enforce financial crimes like Money Laundering Act, Advanced Speed Fraud, and other relevant regulations. It is my submission that this framework enables EFCC to act against currency abuse, safeguarding Nigeria's economic integrity. Then I go to the case studies of the Bobrisky and the Cubana chief priest. So the summary. On the 17th of April 2024, Pascal Okechukwu, also known as Cubana chief priest, was charged by EFCC for alleged Naira abuse, a violation of Section 21, Sub 1 of the Central Bank Act. Following an out-of-court settlement with the EFCC, the charges were dropped. The decision, of course, sparked public criticism as previous cases like the Bobrisky case led to conviction without options of fine, and there are 4 other cases that are out there. The EFCC's out-of-court settlement option, based on Section 14, Sub 2 of the EFCC Act, which states, and again, with your permission, Chairman, I take it as read. This provision basically grants the EFCC discretion to negotiate financial settlements, an approach validated by precedents in EFCC's Studio Law 2019 2 Nigerian Rupee Law Report at 1657 at page 442. This section was strategically used by the Cubana chief priest legal team, allowing him to pay 10 million naira to the Consolidated Revenue Fund instead of facing prosecution. Additionally, the court mandated the Cubana chief priest to promote a naira abuse awareness campaign. So he became an ambassador for the preservation of the integrity of naira. It is reported that Okuneye Idris Olarewaju, also known as Bobrisky, however, did not pursue an out-of-court settlement. I was not on the legal team, but this is what I was able to pick from my research. Hence, the EFCC was under no obligation to offer one. Consequently, the Federal High Court Ikoyi, Lagos, sentenced him to 6 months sentence without an option of fine, as provided by Section 21 and Sub 1 of the CBN Act, after pleading to a 4-count charge bordering on the mutilation of notes of about 490,000 naira while dancing as a social event by spraying the state song. Now, the question is, could the judge have given him an option of fine instead of 6 months imprisonment? Well, that is not my remit this afternoon. So let's compare the two cases. The Cubana chief priest and the Bobrisky cases reviewed divergent applications of Section 21 provision on naira abuse. While Cubana chief priest's case permitted an out-of-court monetary settlement and included a preventive measure in the form of public awareness campaign, Bobrisky faced a punitive outcome with a 6 months prison sentence without the option of a fine. The disparity highlights several issues. The issues are: 1, EFCC's discretionary power in settlement, as guided by Section 14 Sub 2 of the EFCC Act. 2, the role of deterrence in Section 21. The contrasting outcome, a settlement for one and imprisonment for the other, underscores the potential gap in the deterrent effects. The case of Bobrisky serves as a direct deterrent, as the threat of prison time signals serious consequences of violating naira protection laws. In contrast, monetary settlements such as in Cubana's chief priest case may not carry the same weight in terms of deterrence, especially for financially influential individuals, potentially reducing the effectiveness of one's intent to curb the naira abuse. I guess you can draw your inference from the point I am trying to make in that particular paragraph. Then consistency in enforcement and public awareness. For Section 21 to effectively save the naira and discourage currency abuse, a consistent enforcement approach is crucial. While punitive measures serve a strong deterrence, public awareness campaigns can also reshape societal norms and foster respect for the naira. A balance between enforcement and education could reinforce the message that naira abuse, regardless of status or wealth, has serious consequences. And the last one, preventive measures as a complementary tool. The awareness campaign required of Cubana chief priest highlights the role of preventive and educational measures in addressing naira abuse. When integrated effectively, such initiatives can complement enforcement efforts by targeting the underlying cultural practices like spraying and social events that contribute to currency abuse. The contrasting outcomes of these cases suggest that while Section 21 provides a framework for addressing naira abuse, its objectives may be better realized through a consistent, well-publicized approach that combines deterrent penalties with educational campaigns. Clearer guidance on when settlements versus penalties are appropriate may also help ensure that the EFC's discretionary power aligns with Section 21's goal to protect the naira and deter currency. So in this regard, if I may digress, just to say that, for instance, just like we have sentencing guidelines now to guide in cases of plea bargaining, it may help to have such guidelines to guide in terms of how the implementation, the enforcement of Section 21 to be undertaken. And then, of course, I have decided to, even though this was not part of my paper, to add a small aspect, exploring the alternative dispute resolution perspective on the topic of currency mutilation and abuse. So if you permit, Chairman, I think I can just check this quickly. Incorporating alternative dispute resolution methods into currency abuse cases can provide a more balanced approach to justice and the effective propagation of the Save Naira movement. The cases of Bobrisky and Cubana Chief illustrate how ADR can help manage disputes while upholding legal integrity and facilitating flexible resolution. For instance, by one, mediation of out-of-court settlements, as we saw in the Kubna Chief case, negotiation with public interest considerations, and this, for instance, high-profile cases often attract significant public scrutiny, making negotiation within an ADR framework vital. This process can include discussions that involve public advocates to ensure outcomes align with societal interests. Such negotiations can lead to settlements that incorporate public service commitments such as awareness campaigns, thereby upholding holding influential figures accountable and leveraging their platforms to promote compliance with the law. Then, of course, restorative justice approach for reconciliation. I'm sure we all know what that is, so I won't explain. And then integrating ADR into the criminal sanctions. A hybrid approach with that combines ADR with traditional criminal sanctions can enhance accountability. This method allows for financial settlements alongside restorative measures such as campaigns, thereby respecting legal standards while promoting social responsibility. This flexibility can align legal outcomes with public expectations, particularly in cases involving prominent figures. The only thing I need to add is that it should be done in a transparent and accountable way and not shrouded in secrecy. And finally, policy-level ADR and public education campaigns. Given the persistent nature of currency abuse, a policy-level ADR approach emphasizing prevention is necessary. Collaborations amongst the CBN, EFCC, and social influencers can facilitate educational campaigns that reshape public attitudes towards currency handling. This proactive approach could significantly decrease currency abuse incidents and strengthen partnerships. I must say that I had the pleasure once of delivering a lecture at a training for judicial officers where we were discussing Bangalore principles. And this issue of spraying of money came up. And the judicial officer said to me, my brother, this is their culture. My daughter cannot be marrying and people will not be able to spray money. And I said, my lord, the challenge there is that if the matter were to go to court, how would you explain the fact that a judicial officer is there preaching the law and participating actively in that process? So it is important for some sort of policy direction to be given in this regard. Now, what are the challenges to the enforcement of Section 21? To effectively combat the naira abuse and enforcement of Section 21 of the CBN Act, law enforcement agencies, regulatory bodies, financial institutions, and the public must collaborate and implement robust enforcement measures. However, several challenges hinder these efforts. One major issue is the lack of awareness among Nigerians regarding the laws governing the use and protection of naira. This is a given. A lot of people don't even understand that spraying money is against the law. When you tell them, they say, is that true? No, that. In fact, some people call me, when I say I won't spray money, they say, oh no, this you have started, you want to be stingy. Law enforcement agencies face another thing is that they face inadequate resources, including insufficient funding, personnel, and technological infrastructure, which hamper their ability to do this. Then the limited regulation of the economy further complicates the situation, as naira abuse is prevalent in cash transactions that lack regulatory oversight. Addressing this requires targeted intervention and community engagement. Corruption within law enforcement agencies, along with complicity with offenders, also undermines efforts to tackle this. And I think the EFCC chairman mentioned this in his keynote address the other day. Now, what are the strategies for effective enforcement of Section 21? I just hit the high point. The strategies. Yes, okay, sir. The strategies are: 1, awareness campaigns; 2, capacity building; 3, strengthening interagency collaboration of joint operations; and then 4, better legal framework; 5, community engagement initiatives; and 6, monitoring and evaluation systems. If all of these are done effectively, I believe that we'll have a better system of monitoring and managing the use of naira. In conclusion, by implementing the strategies recommended above, Nigeria can enhance the enforcement of Section 21 of the CBN Act, fostering a culture that respects the naira and deters currency abuse through collaborative efforts and informed public engagement. It is pertinent to state, however, that it may not be enough to enforce Section 21 simpliciter. Greater results and outcomes will be achieved if there is an enhanced public enlightenment and engagement on the benefits of upholding the integrity of naira. I thank you, Mr. Chairman, for the indulgence And that is my brief intervention. Thank you.
Thank you very much, Doctor. Doctor, please stay with us. Stay with us until after the interactive session, because I'm sure there will be quite some number of interventions and questions for you to make contributions to. Thank you very much for that high quality contribution from you and intervention. Next, we will go to Chinelu. I'm sure Chinelo will take about the same time as Doctor. So you have 15, subject to extension of.
You know what you don't know. Now you know.